As we look to the future, we have to be concerned about our individual liberty.
This might be a little dated, but I do want to talk about, we recently, in say May, had the 4-year extension of the Patriot Act. And right before, say it was expiring on a Friday, and earlier, a few days earlier than Friday, Senator Rand Paul put an amendment which would clarify that nothing in this extension of the Patriot Act could be used to give the federal government authority to open up private gun records, I guess without a warrant. Am I saying this correctly?
Essentially, yes.
Okay. Did you support that amendment?
Yes, I did, and I voted for it. Well, because anytime you give the government too much authority, you run a certain amount of risk of tyranny. And whenever you have an investigation that can go on that bypasses the courts entirely, there is some concern over that, and there's been some concern related to the Patriot Act. Now, the Patriot Act has a few provisions, and I won't get into all the details because people's eyes tend to gloss over when I do that. Anyone who wants to talk about it should feel free to call me, and I'll discuss the intricacies of it. It's not exactly the same. It's not tantamount to a series of authorizations promoting warrantless, full-blown searches that would ordinarily require a search warrant. But there are some incremental erosions of individual liberties that I think were concerning enough to me that I supported the no vote, and I also supported the Paul Amendment.
Similar to some of the, what some people would say is abuses in, say, banking records and cell phone records. You were trying to avoid that culture that's developed in those industries?
Well, yeah, and in essence what we're talking about is you can use administrative subpoenas to gain access to information held by third parties that historically wasn't deemed by the United States Supreme Court to carry with it the full-blown expectation of privacy that usually triggers the search warrant requirement. Increasingly, as our society has gotten more technologically advanced, as we've relied a lot more on third-party providers of technology services like cell phone service providers, internet service providers, and so forth, we've entrusted a lot more of our information that would previously have been kept in a private place to outside third parties. And so there is a policy concern that's rooted in and consistent with the same concerns underlying the Fourth Amendment that says maybe we ought not make it so easy to get those just by means of an administrative subpoena, especially if, as is sometimes the case under the Patriot Act, as is often the case under the Patriot Act, the administrative subpoena in use carries with it a secrecy ban, a gag order, if you will, that says you can't go out and tell anyone that you received this as a third party. You see, in most instances, if a rogue prosecutor or regulatory official goes out and tries to get too much information, is abusing the administrative subpoena power, there's at least the risk that somebody's going to out that regulator or that prosecutor. But whereas here you've got criminal sanctions accompanying the release of public of information about one of these administrative subpoenas, there's a little bit more risk of mischief. And again, my point is not to impugn the motives or the conduct of anyone who's actually implementing this. I think we've got a lot of fine people over at the FBI, and I think they're doing a great job protecting us. The point is, as we look to the future, we have to be concerned about our individual liberty. We can't allow it to be eroded and eliminated on a step-by-step basis. Very often this is a one-way ratchet, and it's one that doesn't work out well for us if we fall asleep at the switch.
So you'll extend them the goodwill and give them credit for that. It's just that things that used to be kept in my desk drawer are now being kept at another company. And is that now public domain? Is it the same? Do we treat it as if it's still in my desk drawer, or did I leave it out on the sidewalk?
Yeah, and the short answer to that question is it's somewhere in between. It's not your desk drawer. It doesn't require a warrant under existing case law. Some would argue, with some good reason, that maybe it ought to be. But no matter what, we know that it's somewhere along that continuum, and I think people do have something akin to or approaching a reasonable expectation of privacy in that, and it ought to be given a modicum of protection. There, at a minimum, ought to be protections in place so that in the future you can't have government agents running roughshod over our individual liberties.